Welcome, everybody, to the Labor and Employment Law section, key case updates for the cases published during the month of November 2025. I am Javier Rivera Carbone, workplace attorney, investigator, and today I'm joined by Michael Velarde, who has been practicing employment law for many years, representing employees, and we're going to be discussing the cases in the summaries prepared by the law firm of Payne and Fears, a copy of which you received together with the link of this video. And with that, I would like to move on the case summaries on page 1. Michael, there is a case there where you're going to mention to us what happened. Please go ahead.
Sure. So the first case that we have, Hollis versus R&R Restaurants, Inc., involved a dancer at a strip club in Portland who had sued for misclassification, as you might imagine, as an independent contractor. So she sued the corporation as well as the club's owners and managers. And what happened was she had an upcoming job position at a different club. We'll call it a third-party club. But that club was managed by one of the defendant managers in the present case. And so what that manager did is he canceled her upcoming, her upcoming job at the other location. So the plaintiff amended her lawsuit to allege retaliation. The defendant took the position that it can't be retaliation because she was not yet employed at the third-party location, so she's not an employee to even be able to invoke a retaliation in that context, which is kind of a technical argument, which the Court of Appeal rejected and said that she does not have to presently be employed at the third-party employer for the retaliation to constitute retaliation. The cancellation of her job constituted retaliation. And then, of course, the other takeaway, interesting thing to note, which I didn't even see contested in the opinion, was that the retaliation, just from the big picture perspective, was occurring at a third-party location. However, the manager that was executing the retaliation was a defendant in Hollis versus R&R Restaurants. So the other takeaway is that if you have a named manager defendant or even a corporate defendant who's retaliating in a manner that's external to that employer, it can still constitute retaliation. I believe this retaliation was under the FLSA. But yeah, that's the takeaway from Hollis.
Mike, from the perspective of defendants, I think a takeaway from this case is to be mindful that even though you may be able to prevail on summary judgment on what the court felt like it was a technicality, the fact that the plaintiff was not yet an employee of the other place, right? That's why summary judgment was granted, I understand. Be mindful that at the end of the day, it's about what happened. So in this case, it seems like the only reason why this lady did not work at the other place, the third party, is because of one of the defendant's actions. So the actions of a defendant may lead to a cause of action for retaliation in your case, even if the act of retaliation is going to happen or happened at another location with another employer.
Yeah, and I think, the fact there is that she did already have another job at the third-party location, it was called Dante's, scheduled to commence in the future, and then that was canceled. So she was able to point to a concrete action, not just a vaguer kind of failure to hire, but an actual cancellation of a planned job.
So plaintiffs may go over a technicality, defendants, be careful.
Yeah.
Be careful. Thank you. Now, on that same page 1 of the Payne and Fears summaries, I am going to look into the case of Lorenzo v. San Francisco Zen Center. And this is a case dealing with the religious exemption. And in that case, as we all know, when a defendant is a religious-based organization, there is a presumption that employment laws do not apply if they interfere with the faith or the governance of the church. So in this case, what happened is that this person was training to become a minister, and as part of that, they worked for no compensation other than lodging, food, and a stipend. And the plaintiff filed a claim. The trial court granted summary judgment because of the ministerial exception and went to the Court of Appeals. And the California Court of Appeals ruled that the exemption does not apply for wage and hour cases because the allegations did not interfere with the religious doctrines. It did not interfere with the governance of the church. In this case, the argument of defendants was that working or the work practice is part of Zen. So when you train to be a Zen Buddhist, I guess, working is part of it. So any issues related to work was part of the faith. And the Court of Appeals ruled that they didn't see any connection or any allegations that the wage and hour claims affected the faith, or that the wage and hour claims affected the missions of the church itself. And for that reason, it allowed a lawsuit under the labor code. The takeaway for defendants, I think, is that when representing religious organizations, be very mindful of this ruling and make sure that in order to raise this defense, the allegations of the plaintiffs affect either the faith or the governance of the church. If it does not, then the case is likely to continue, as in this case for a wage and hour claim. Mike, from the perspective of plaintiffs, what do you think?
Well, it's interesting. I think in a way it reminds me of the holding that we just discussed in the Hollis case, which is from a public policy perspective, these laws are designed generally to protect employees. And it seems, this may be somewhat cynical, but the trial courts kind of sometimes see it as their job to grant motions against us, and the appellate courts kind of see it as their job to uphold public policy. So good for them. That's the plaintiff's takeaway.
Let me ask you a follow-up question, if you don't mind, because in this case, a wage and hour case, somebody was working for free, it seems, right? So that is in conflict with the California public policy of people being paid for work. But do you think that, Mike, that this holding is going to affect FEHA cases when the allegation is discrimination, different treatment, or retaliation?
That I'm not sure, because I've only researched this somewhat briefly in consulting with a friend about a case about 6 months ago. So I certainly didn't review it, to be able to speak to it specifically. But I think that the FEHA language is a little bit more clear in the statute. So I suppose it's possible that it could go in that direction, but I think that might require amending the FEHA itself.
I agree with your instinct that it seems pretty solid that a discrimination or different treatment allegation, it goes to the heart of faith, right? And that exception may not be allowed a case to continue. But just to be careful, the argument could be made that if the discrimination or retaliation allegations do not affect faith, do not affect governance, they may continue. I don't know. Interesting. Now, continuing on the next page of the summaries, on page 2, at the bottom, I'm going to mention the holding of the case of Mora v. CE Enterprises, Inc. And this case is kind of wonky because it deals with the labor code as it relates to compensation on a piece rate basis. As we know, a couple of years back, in response to a California Supreme Court case, there was an amendment to the labor code that strictly regulated how people can be paid on a piece rate basis. And they made it, the assembly, I was going to say politicians, made it really, really hard to establish a piece rate compensation plan. Well, this case is an illustration of how an employer went ahead and tried to do something different. And this case turns on flag hours, which is in the auto industries, for those that have worked with auto dealerships, is a way of paying people for working on cars by a specific amount of time that has been predetermined by dealerships, all of them, and how long it takes to fix a car. Well, in the cases that have gone to the Supreme Court, they have decided that those flag hours need to compensate and account for non-compensable time or time not working on a car separately from the additional compensation or higher compensation for repairing cars. And that scheme, as I mentioned, is hard to do. So what this employer did was to pay all technicians a minimum wage, twice minimum wage actually, and to then separately pay a flag bonus. And by calling it a flag bonus and by making it separate, the Court of Appeals felt that this was not a violation of the labor code. Plaintiffs insisted that this was just a different name for the same thing and that this was an illegal piece rate compensation plan. But kudos to the California Automobile Association that under their guidance, this dealership was able to establish what they call a flag bonus. And it's just interesting to see how an amendment takes years for the courts to finally say that what the employer did was legal and not in violation of the labor code. So that's why I wanted to mention it. For those that deal with it, it's important. For the rest of us, this is an example of how a change in the law, we're going to find out whether it's legal or not a few years down the road. Now, moving along, on the last page, for purposes of today, we're going to go to page 4 of the summaries. And at the bottom, there is the case of Brown v. Dave & Buster's of California Incorporated. And Mike, if you can please discuss that case for us.
Yeah, of course. So this is a PAGA action. So Lauren Brown brought a PAGA case against Dave & Buster's. And in this case, she was actually the 5th to file. So there were multiple PAGA claims that have been brought against Dave & Buster's. And Dave & Buster's was able to resolve one or two of them. But for the purposes of the opinion, they kind of boil it down to one. Another plaintiff called Andrade. So that was one of the previously filed cases. So Dave & Buster's entered a PAGA settlement with Andrade, global settlement covering everything at issue in the cases, and then, is ready to sort of move on with its life. But, Lauren Brown was not ready to move on with her life. Lauren Brown wanted to stay in the action. So she came up with a couple theories because Dave & Buster's filed a motion for judgment on the pleadings against Brown on claim preclusion, arguing this has been resolved, this is done, you don't have a case anymore. So Lauren Brown came up with two theories. Her first theory was that she should be able to continue with her claims following the settlement date. The court approved the settlement on November 4, 2022. So Lauren Brown, I guess, had a theory of continuing violations and wanted to be able to continue with those claims. The court rejected that because Lauren Brown's employment with Dave & Buster's ended in 2018. So the holding was pretty straightforward, that a PAGA plaintiff lacked standing to pursue violations that occurred after their employment had ended. So no standing, so Lauren Brown cannot continue in that fashion. For the second one, her attorneys dug in a little bit on the details and found that with respect to Andrade's case, the claim for vacation pay violations was not in Andrade's original complaint, and it was not actually raised until her second amended complaint. So Andrade brought a second amended complaint and added vacation pay violations to that. However, when she did so, she only waited 35 days from her amended pre-suit notice to the agency that she was going to be adding these claims. The statute says you have to wait 65 days. She waited 35 days before filing the second amended complaint. Lauren Brown's attorneys became aware of this fact and tried to argue that Andrade did not have representative capacity with respect to the vacation pay violations because she didn't satisfy that, that Andrade didn't satisfy that procedural requirement. In this case, the Court of Appeal also rejected Lauren Brown's arguments on that point and found that Andrade had complied with the longstanding doctrine of substantial compliance. Basically, that her pleadings, her notices to the agency, her pleadings, they were inclusive, they said what they needed to say. And the fact that she filed after 35 days instead of 65 days is not going to be so significant that they throw out the whole thing. That was, or throw out the vacation pay issue, I should say, that it was in substantial compliance, and that was good enough. So Lauren Brown at that point was out of luck, and that was the holding.
From the perspective of plaintiffs, was this good, bad, indifferent?
I mean, I would say that I'm a little surprised that Lauren Brown's attorneys were trying to stick with it this long. It doesn't surprise me that the court went in that direction, but at the same time, I would consider it unpredictable. It'd be one of those things that, I mean, honestly, if they peeled this up to the next level, it could go the other way. So who knows?
I agree. From my perspective, it was interesting to see that the court said that it was a harmless defect,
Right.
and then help the employer. Well, I can only wish, from the perspective of defendants, that employers will get the grace of a harmless defect, because that's what PAGA is all about. Sometimes a harmless defect is going to cost thousands and thousands of dollars.
Well,
So, yeah.
what is interesting in
Go
the
ahead.
framing of the opinion is the appellate court framed it as though they were helping Andrade, that, plaintiff shouldn't be punished for acting too fast. There was some language like that. Well, the reality is this is a decision that helps the defendant, right? This is a decision that helps Dave & Buster's more than it helps, one plaintiff versus the other plaintiff. I mean, Andrade has her settlement one way or the other. So from that perspective, I mean, what would happen if I brought a FIA case and didn't file a right to sue first? There's not a lot of wiggle room on that. So it does look a little bit like the Court of Appeal trying to kind of go out of its way to help a settlement hold together and not allow it to continue under another plaintiff. So again, who knows? Maybe the Supreme Court would see it differently.
And I agree with you that the reasoning was to assist the employee. It was harmless, but the end result was that the employer was better off for it.
Right.
So if this doesn't hold, then what happens with Andrade's settlement and what happens with the new lawsuit? And the courts seem to be struggling still with PAGA. 20 years later, we're still trying to find out what it means under PAGA. So that's the latest and greatest. Thank you, Michael, for your analysis of this case, and thank you for your analysis of the other cases. Thank you, everybody, for your attention today, and to the law firm of Payne and Fierce for preparing these summaries. I want to invite you to attend the January 2026 meeting of the Labor and Employment Law section. In that meeting, all of the cases from last year, all of the new laws for 2026 are going to be discussed. So join us on January 6, 2026 in-person meeting. It's going to be great. So see you there.